Bill C-71 before us today seeks to amend the Citizenship Act to do three things. First, it would ensure that children not born in Canada but adopted by Canadian parents would be treated as Canadian-born citizens for the purposes of passing on citizenship if they have children abroad in the future. This is something I support. Secondly, it would restore citizenship for individuals who lost it due to non-application for retention or rejections under the former Citizenship Act, Section 8. Again, this is something I support. Thirdly, and most importantly, it would abolish the first-generation limit for Canadian citizenship by descent established in 2009 and replace it with a substantial connection requirement which would allow a foreign-born Canadian citizen to pass down their citizenship to their children and grandchildren born abroad so long as they have spent at least 1,095 days in Canada cumulatively. It is this portion of the bill that I have concerns with that I will outline here today. The first issue relates to the hot-button issue in British Columbia for many years of birth tourism. Birth tourism has long been an issue in Canada, and this bill leaves the door open to the practice continuing long into the future. In fact, it would encourage it. For those that don't know, birth tourism is the practice of traveling to another country for the purpose of giving birth there. This is generally done to obtain citizenship for the child, taking advantage of our birthright citizenship laws. In Canada, there are three pathways to citizenship. The first is known as jus sanguinis, or right of blood, in other words, being born to a Canadian parent. The second is naturalization, the process of immigrating, obtaining permanent residency, and eventually citizenship, as my previous colleague alluded to. The third is jus soli, or right of soil, in other words, being born on Canadian soil. A 2023 article in the National Post discussed jus soli, highlighting how a single hospital in Richmond, BC had 502 non-resident births in 2019. Across Canada, 4,400 non-resident births took place in 2019, more than triple the number in 2010. In 2023, the first baby born in Vancouver was born to a birth tourist. The mother even told local reporters she had made her first ever trip to Canada specifically to secure a Canadian passport for her daughter. A 2020 CBC article titled "All About the Money: How Women Traveling to Canada to Give Birth Could Strain the Healthcare System" highlighted that Canada is in a small minority of fewer than 36 countries who grant citizenship based on birthplace, regardless of parents' nationality or status. It noted that a high concentration of non-resident patients giving birth in Canada has led to compromised care for local mothers-to-be and nursing staff. Another article in 2023 noted that while air travel restrictions during the pandemic slowed down the trend, numbers have started to increase again right now. It highlighted that of 102 non-resident women who were surveyed after giving birth in Canada between July 2019 and November 2020, 77% cited birthright citizenship as their primary reason for giving birth in Canada. It is very clear that this pathway to citizenship is being abused, and this program will only see the numbers increase as the Liberals reduce security checks for visitor visas as well. Therefore, thousands of children each year are born in Canada and leave with the full rights and privileges granted to any other Canadian. And should they choose to come back to Canada at any time in the future, they will have access to Canada's healthcare and generous social security benefits without the requirement to pay any taxes before they arrive. Right now, Canadians are paying more taxes while getting less. How is it fair to Canadian taxpayers? Even Liberals have recognized that this is a big issue and called for change. In 2018, the former Liberal MP for Steveston Richmond East, Joe Pescalito, tabled petition E1527, which called on the government to address birth tourism, citing its exploitation of Canada's generous public health care and social security system and violation of Canada's sense of fairness. I would be remiss if I didn't note that when the first generation limit was brought in 2019, Liberals even voted in favor of it at third reading in the House of Commons. How is it just that a birth tourism baby will be able to pass on citizenship to their grandchildren under this proposed law. That is the big question today. Citizenship will be passed on to the grandchildren of Canadians born here solely for the purposes of obtaining citizenship. For my constituents, that is not just. The second issue I have to raise in respect to this bill are the obvious ramifications of eliminating the first-generation limit, namely the capacity of Immigration, Refugee, and Citizenship Canada to meet its current obligations on top of the additional files this law will inevitably create if it is passed. Earlier today in the minister's remarks and from questions from the member from Calgary Shepherd, the minister was not able to respond to the number of people that will be impacted by this law. That is irresponsible. This proposed legislation could lead to tens of thousands of additional files to process, leading to even more backlogs in our strained immigration department. In the Ontario Superior Court ruling that led to the legislation proposed here today, the court cited a 50% error rate even among the samples that were cited during the court proceedings. We already have seen the effects of an overcrowded immigration system. In fact, we're living them today. Checks are being missed, and dangerous people have been allowed into our country due to a lack of due diligence and effectiveness by our officials. Just over a year ago, Harjeet Singh Nijjar was murdered outside of Gurdwara in Surrey. It was revealed that his alleged murderers were in Canada on student visas. In just the last months, the RCMP have foiled multiple terror plots by people who had recently come to Canada. In the spring, RCMP officers foiled a plot by a 62-year-old Canadian citizen who had been filmed taking part in a beheading on behalf of ISIS in 2015, which was not found before he was granted citizenship. Then over the summer, we learned of the arrest of a 20-year-old Pakistani citizen who obtained residency in Canada, who is planning to commit a massive attack in New York around the anniversary of Hamas's barbaric attack on Israel on October 7th. His plan was to kill as many Jews as possible. With IRCC already failing to ensure dangerous people are not granted visas, PR, or citizenship, how can we trust that they will be able to effectively track the 3-year significant connection clause for potentially tens of thousands of new applicants on top of our already overburdened system? Additionally, this bill does not require individuals granted citizenship to undergo criminal background checks, posing even more security risks and undermining Canada's standards for who can become a Canadian citizen. The third issue I'd like to raise today relates to the Supreme Court. It relates to the Supreme Court and the lower court in Ontario. When it comes to something as important as the granting of Canadian citizenship, I believe this decision should have gone to the Supreme Court of Canada and not a provincial court judge in Ontario. If I had more time today, I would also raise points on the financial implications of this bill and the effects it could have on Canadians, on our democracy and voters abroad in future elections. And finally, on the financial implications as well, the government has not been able to provide any estimates in respect to the cost that this bill will have on Canadians. As was referenced in this House already multiple times today, the former Conservative government brought forward a first-generation limit in response to the crisis in Lebanon in 2006. That cost Canadian taxpayers over $94 million. And as my colleague from Edmonton outlined, many of those people left Canada after they used our consular services and generous supports that Canada used to protect them. The question before us today is, do we really want to create a new wave of Canadians of convenience? In closing, I do not believe that that is a good idea to extend citizenship to the second generation born abroad for the reasons I've been able to briefly outline. Thank you for your time, Madam Speaker.
I wonder if the member can expand upon his thoughts in regards to the Superior Court in in the province of Ontario with the decision. The Conservatives have taken the approach that they would have appealed that decision. Would the Conservatives have agreed if the higher court would have reinforced that particular ruling, or would they have potentially, given their opposition to it, used the notwithstanding clause?
The fact of the matter is that I believe our citizenship is sacred. It is something that all of us, especially in this room, have a responsibility to uphold and to dignify. And I believe that the questions, a question of such importance, namely who is able to be granted Canadian citizenship, should not be determined by an Ontario Supreme Court judge. I believe it would have been in the interest of Canada and the Government of Canada to appeal that decision to higher courts, so ultimately the Supreme Court of Canada could have made a decision on jus soli and its implications moving forward. That said, I will not answer a hypothetical question about what the Supreme Court could or could not have done. Thank you, Madam Speaker.
My colleague's speech fits into what I was saying earlier. It speaks about many things without answering the main question. An example, a Quebec couple goes to work abroad for the Quebec province. They have a child, they come back. This child lives in Quebec and therefore is Canadian. This child, as an adult, goes to work abroad. They have a child, but that child would not have Canadian citizenship. That doesn't make sense. Does he not agree?
Right now, the Bloc Québécois have a serious determination to make. Do they stand with the Liberals in centralizing more power in Ottawa and removing the powers of citizenship under Quebec's rules? I do not believe that the 1,095 cumulative days is a good test for determining citizenship. Thank you, Madam Speaker.
Something that's come up frequently is talking about this court case. What I understand is that it's a lower court decision. And what really interests me is that the Liberals talk about this decision and how, well, why should it have been appealed? And I will remind the Liberals here that there was a decision of a year or two ago from a court of appeal that they didn't like because it was about oil and gas. And that very day, the Prime Minister marched in here and said, we will be appealing. Why? Because it fit his narrative. I wonder what this member has to say when the Liberals seem to talk out of both sides of their mouth about whether things should be appealed or not appealed like this.
I will admit I am not an expert on constitutional law like my colleague from Kamloops, but I do know, like every other Canadian, that intuitively our citizenship is something that is sacred. It is something that needs to be upheld, and that a lower court decision should not be the determining factor on a matter of such importance as determining our citizenship. I will note again that the Liberals on February 15th, 2008, voted to eliminate the second generation provision that is being debated here today. And I think the Liberals back then made a right decision, and I call upon the Liberals to listen to their constituents and uphold the citizenship law as it is today in respect to the first generation limit. Thank you, Madam Speaker.